I'll call the Wolfeboro Board of Selectmen meeting for Wednesday, May 4th, 2022, 6:30 p.m. Jim, is there any non-public tonight?
We have two items, one under 91A, 3, Roman numeral 2, lowercase a, employment, and 91A, 3, Roman numeral 2, lowercase d, acquisition, sale, or lease of real property.
Okay, thank you. Consideration of minutes of April 6th.
Mr. Chairman, they were not in the packet. I'm still working on making some of those changes, so I would like to make a motion to table them.
Second.
All those in favor? Aye.
Aye.
First thing is a public hearing, town ordinance amendment. Town of Wolfeboro to hold a public hearing on Wednesday, May 4th, 2022, 6:30 in the Great Hall of Wolfeboro Town regarding amendments to a town ordinance, Chapter 36, Docks and Wharves, 35-5, limitations on use of town docks, wharfs, ramps, 35-7, commercial vessel landing permit regulation and fees. Jim, are you going to deal with that one?
Mr. Chairman, I'm going to step down from this. I have a conflict of interest.
So noted.
So, Mr. Chairman, board, and members of the public, if you recall last year about this time, we went through a conversation about making some changes to our docks ordinance. We, at that point, tabled most of the work until the recreational dock work was completed. That is all complete at this point. I've gone through, work with the staff and members to update the ordinance, and we have a total of 8 proposed changes. If you like, I can go through them one at a time.
Yeah.
If however you want to handle them, whether you want to vote on them one at a time or as a bulk item, however you want to do it.
Vote on them, I think, one at a time. Be the easiest.
Okay. So item 1 is relative to attaching the commercial vessel landing permit and sign permit to the dock ordinance. Previously, it was not attached to the ordinance. It was a standalone document. This merges the two together. Pretty straightforward. No major issues here, just a house cleaning issue.
Would you like a motion?
Yeah, go ahead.
I move to approve the addition of the commercial vehicle landing permit and sign permit to the dock and wharf ordinance.
Second.
Okay, any discussion? All those in favor?
Aye.
Just so everybody knows, Selectman Harriman will be here tonight. He's on his way from Nashua, so he will be here at some time.
Okay. The second change is the dock configuration. If you recall, previously there was a lot of question about how the docks were laid out. And then when we went through the reconstruction of the docks, they were laid out A through G, and then commercial docks 1 and 2. We've attached an appendix outlining that map to this ordinance, and all that this particular change does is identifies the addition of Appendix A to outline the dock configuration.
Any discussion on that?
Would you like a motion?
Yep, that would be good.
I move to approve the addition of Appendix A, dockside dock configuration to the dock and wharfs ordinance.
Second.
All those in favor? Aye.
Aye.
Okay. The third one discusses the municipal electric boat. It discusses the location of the fireboat and the U.S. mail boat. It just identifies those as docks G and docks F for the electric boat. Those are the only changes.
Okay, I'll make a motion that we change that in our ordinance.
I'll second that.
Any discussion? Brian? All those in favor?
Aye.
The fourth one brings us to removal of some of the previous language, docks A and B, and simply refers to Appendix A for the location of commercial docks 1 and 2.
Okay, any discussion? Have a motion?
Motion to approve language changes in Section 36-5F of the Docks and Wharfs Ordinance to read, a commercial vessel landing permit issued by the Board of Selectmen pursuant to 3650, 36-5P, and 36-7 must be obtained prior to the commercial. Is that the right one? Yeah. Must be acquired. All other docks shall be recreational except for the provided by the ordinance.
I'll second that.
Any discussion? All those in favor? Aye.
Okay. Change number 5, again, it refers to the titling of the docks. It reads, the area to the north side of dock G, opposite where the fireboat is located, and the area on the south side of dock F, where the electric boat is located, shall be designated as areas for loading and unloading of passengers, provided, however, that potential loading and unloading would not exceed 10 minutes. This is one of those items we discussed heavily last year about trying to have 2 places for temporary loading and unloading of passengers.
Okay, I'll make a motion that we change that as it was read.
I'll second it.
Any discussion? All those in favor?
Aye.
Aye.
Anybody opposed?
Okay. The next change to Section 36.5M2 to read, island resident boat parking shall be permitted on Dock A at the dockside during periods of high water and low water when passage under the Smith River Bridge restricts passage, and further limited to the time frame between ice out and the day before Memorial Day weekend, and from the day after Labor Day to the end of the fall boating season.
Make a motion for that.
Yep, I'll move that the island resident boat parking shall be permitted on Dock A at the dockside during periods of high water and low water when passage under the Smith River Bridge restricts passage, and further to limit the time frame between ice out and the day before Memorial Day weekend, and from the day after Labor Day to the end of the fall boating season.
Second.
Any discussion? All those in favor?
Aye.
Okay, and this is the big one. So the proposal that was discussed at the last meeting was relative to charging fees for commercial vessel landing permits, usage of the Libby dock. That has traditionally been a $25 permit. We've done a lot of research, and what we've been able to tell at this point is we've never collected any of that. We had Brenda LaPointe in Billing and Collections go through it. Casey in Finance went through it. We were able to identify revenues associated with the Libby, but nothing associated with revenues from the Libby dock. So again, this one has been for a long time, $25. The board at the last meeting discussed potentially up to $3,000 for a single-year permit for a business. Just some background information here. 3 years ago, we spent about $32,000 on the repairs to the stone wall, seawall at the Libby Park. We've spent about $28,000 on the launch, reconstructing the launch as it was in failure, and we've got work to do on the dock down there going forward as well. These commercial docks come in, they use that heavily, and the question is, should they be helping to offset some of the expenses with it. I'll let you deliberate.
Any discussion amongst the board?
Yeah, I have a few questions. Are we going to have a person who is going to issue the permits, a place there to come? Are we going to have a permit form? Are we going to put that up on the town website so that we had it and we didn't do anything? Don't we need other documents and a process here?
So we did put into the commercial vessel landing permit a section titled Circle Here If a Barge Company. I would assume that this, we're looking at about 8 different users of it, if my understanding is correct. And I believe that this is something that Amy and I could handle, as it's really once a year to come through and find out who's doing it, issue a permit to them, and go from there.
Jim, where will the funds be held?
So that's a fair question. I know there's been question regarding the establishment of a revolving fund. It's my understanding that a revolving fund may require approval of the voters. So that's something that we're researching behind the scenes to place those funds so that they can be utilized for repairs at the Libby, docks and wharf.
So if we collect it this year, we won't have the revolving fund, so we'll put it into the general fund, and that money then will offset some of the expenses we have for the Libby Museum.
Correct.
Yeah, I'm comfortable with $3,000. I think that it's heavily used, and I think it's a way for us to be able to keep up and maintain that. I know the ramp quite often gets so that it's hard to launch the boats there. We may need to spend more money on doing that, and the stone wall and the dock itself. So I'm comfortable with $3,000.
Okay. Is there anybody who wants to speak to this town about the wharves?
Hi, my name is Paul Goodwin. I own Watermark Marine Construction, and I think this is a fine idea. It's very similar to what we do in Guilford. We've done it for about 10 years now. Guilford does it a little bit different. If you're from Guilford, you pay a different rate, and you get 3 passes. But a couple of the issues there are it's very difficult to enforce it. So I will write the check tomorrow to be the first barge company that would sign up for this. But I think it's fair to pay to play. We're doing the damage, allegedly, and we should pay to do it, or wear and tear. So I'm fine with that. But we should define what a barge is. And so this is a lot cheaper than we pay at the other 2 ramps on Winnipesaukee and the ramp we have on Sunapee. So I'm in favor of the concept, but I'm not sure about the bond thing. That's a very low number for a bond. I don't know if anybody could even get a bond for $1,500. So maybe that should be higher, or no bond. But I think there should be a certificate of insurance required as a component of the commercial. I guess you're going to call it a commercial license or commercial permit, so that somebody would have to be insured, which may cover you on the bonding issue if that's the intent. So I'd say I'm in favor of it.
Thank you.
And could I just get your name again?
Pardon?
Could I get your name again, please?
All good.
Thanks, Paul.
Watermark.
Anybody else want to speak to this? Not, I'll close the public hearing. Board? We want to put into place, make a motion to put into place a $3,000 fee for barges to utilize Libby Museum ramp and dock.
I'll second that.
Any other discussion?
Do we need to have any amendments to this so that, should we say that the companies need to have proof of insurance, or is that going to be?
I believe we can handle that through our existing policies.
Okay.
As any vendor utilizing town property, I believe would fall in those parameters.
So all those in favor?
Aye.
Anybody opposed? Okay, the next temporary event permit.
I got one last change, Dave, that
Okay.
was on the document you received today, and that's regarding the signage. And this is 36.7H4 of the Docks and Wharfs Ordinance to read as follows. The two vessels having the longest history of receiving a commercial vessel landing permit from the Board of Selectmen shall have rights to signage being placed between the top and middle rail. All others shall be placed between the middle and bottom rail.
I think that makes sense because the Mount Washington and the Winnipesaukee Belle, no, the Millie B have been there. And that allows the two newer, smaller boats to go on the lower level. I did ask Jim, we have the Winnipesaukee Belle with a A-frame on the dock, and we don't have anything in the ordinance saying that that's okay. But I believe, don't we have a ordinance in town that a business may have one A-frame sign on the sidewalk? So
Travis is shaking his head no, so
I think we do.
we'll look into that.
I think we do. I think we had an issue with signs and that we did
3
allow
years ago.
an A-frame up next to the building, so we probably should check on that.
We'll look into that.
Okay, anything else?
Please. I'll make a motion to amend 36-7H4 to add the wording that Jim just read in about the two longest history boats of the commercial vessel landing permit would be awarded the top two spots for the signs, and the other ones would be between the middle rail and the bottom rail.
Second.
Okay, all those in favor?
Aye.
Okay, we all set with that one? Okay, the next temporary event permit. The Wolfeboro Board of Selectmen to consider a temporary event permit for Wolfeboro Historical Society to host a vintage market on July 9, rain date July 10, 2022, from 11 a.m. to 4 p.m. at the Clarke Museum Complex. Anybody here to speak to that? Sir?
My name is Gene Deneau. I'm a director of the Wolfeboro Historical Society, and I'm speaking on behalf of the Board of Directors of the Wolfeboro Historical Society. At the last meeting, there were some discussions started about the issue for you, but they were cut short because of, let's call it, a technical problem. I assume that problem has been resolved.
Yes.
Okay. A brief review for the people that don't understand what the issue is. In 1915, Greenleaf Clarke, who owned the property and quite a lot of properties in Wolfeboro, donated or indicated in his will that it would be donated on his death a considerable section of town from South Main Street, basically southwest, for a distance of about 580 feet, also bounded by Clark Road and East Clark Road. In that document, he put a restriction in not to be used for any ball games or athletic sports. We don't know what his problem was, certainly unusual clause. That's not an issue here. He actually donated the land ahead of time before his death in 1917, which was the 100th anniversary of his grandfather's purchase of the land. That meant something to him. This is where he introduced words to the effect that it should be a public park with quiet character and used for restful purposes. A few years later, in 1927, the town gave a 99-year lease to the Wolfeboro Historical Society, which was formed in 1925. One of the key things about this date is it didn't first arise in 1927. It was voted on a year earlier in 1926 by the Board of Selectmen. And what's important about this is that Greenleaf Clarke knew about the provisions of this particular lease because he was the vice president of the Historical Society in 1925 and 1926. It's definite, it's assumed that he knew the terms of the lease because the Historical Society was holding regular meetings. The lease is a very simple, standard lease with no restrictions about ball playing, no restrictions about restful purposes. It has only the normal restrictions saying no offensive trade or building, and make sure you don't keep the ashes in the building. That was very important in those days because of the danger of fire. I should note that if you don't want to take extensive notes here, that's okay. I'm going to hand out copies of most of what I say in a few minutes. We have a long history of outdoor events on the premises. Since about 1934, which is the first document I could find, when we held a garden party there have been a long string of events. In recent years, it's been at least one a year and many more. It included gardening parties, opening day parties, antique and craft shows. In 1972, we even had a very large anniversary party there. We've had yearly airing of the quilts outdoors, publicized and attracting people. We've had military encampments, French and Indian War people. An encampment means you bivouac and you stay overnight. We've had several fall apple festivals with demonstrations, things like blacksmith shop, apple pressing, baking contests and judging with prizes given out. We've had children's history sections. For a few years, we had them 5-day sessions with the children playing on the property that was under lease to the Wolfeboro Historical Society, which, by the way, was not the entire 580 feet, but only 300 feet. The last 280 feet leading to Goodrich Road, which wasn't there at the time, never had anything to do with the Wolfeboro Historical Society. There's also a problem with the 300 feet, which I'll explain in a little while. We've had, in addition to that, the Rotary Christmas tree sales have been held there. We've held Halloween there, and a few other organizations have partnered with us. The only full retail market was a farmer's market. That had nothing to do with the Wolfeboro Historical Society, and that really outgrew the grounds. It became a problem. We never disagreed with that problem. There were never any complaints about any of the activities of the Historical Society until the farmer's market came, which had nothing to do with the Historical Society. The two major complainants lived in the area for 55 years and 28 years, respectively, and never had any complaints about any of the Historical Society activities. There was a question asked, I believe, Mr. Deshays, I believe you asked, why can't we move some of our events to another venue? Well, it's very simple. We're not in this just for fundraising. There's a second problem. Many people, even longtime Wolfeboro residents and many of the summer residents, don't even know we have a museum there. We've been shocked at some of our events to find that people have learned for the first time that we have exhibits in the building. Museums in recent years have suffered with attendance problems. There's no way Greenleaf Clarke could have anticipated the change in the way we live today. Everything is electronic. You want to go to the Louvre? Look it up on the internet. We need to get people into the museum to see all the exhibits we've got. Our museum is filled with 4 buildings complete with exhibits of the period. That's part of our charter, is to keep the interest up in the history of Wolfeboro. Now let me say a few words about Greenleaf Clarke. He was not against activities on his property. During the time period in question, the mid-1920s, 25, 26, he actually built a dance floor on part of his property. He held concerts there and regular dances. He did not charge admission. He even advertised parking for 500 cars. He owned 103 acres in the area, going all the way down to the lake at that time. We also had a number of winter carnivals. He owned the area down by what's now known as Clarke Point, which is a small park, and I believe that's where an area was called Clarke's Camp at the time. Part of the winter carnivals was a walk through Wolfeboro along the shore. When they got to his camp, there were drinks and hot dogs. He also, in one year, his property was used, in fact, Clarke Park was used as the staging area for the 4th of July parade. All these documents are in the Granite News, and the document I'm going to hand out has copies of that. Go ahead and distribute that to interested parties. Another thing that happened was his original will left the income from his tenement houses to 3 different churches. This has nothing to do with the Historical Society, but is indicative of his behavior at the time and the fact that he wasn't against entertainment. His original will simply left it to them. In around 1927, he made a change to the will, which was also documented in the Granite News, and he added a clause that affected the donation of these to these 3 churches. He recognized that his tenements were not in good repair, and they would need extra money to maintain them to the satisfaction of the renters. So he dictated that, in a new clause, the churches were to provide entertainments using local talent, musicians, entertainers, singers, in order to raise extra funds to maintain these buildings and be able to use the rent to pay for taxes, insurance, and money for the church. That's in the document that Pat is somewhere about to hand out. Okay. I should point out that all the activities that we've done over the years have been quiet activities. We do not play rock and roll music. People walk through the park. That's all they do, is walk. They look at exhibits, they don't make noise, and in fact, the noise from the traffic on Main Street is louder than any noise we've ever made. I'd like to also point out that we are not the only ones affected. There are several other activities that involve this discussion today. Certainly the Wolfeboro Historical Society is one. Another one is the Christmas tree sales. Sure, they're retail sales, but the money goes to charity. Those are held yearly. We can't move those. I'm trying to speak a little bit for the Rotary now. They may have some comment. I'm not sure if they're here or not. But one of the big reasons that they're coming to our location, and it's been very successful, they've sold out every year. We have the available parking. It's off Main Street, so they're not blocking traffic. They also have the advantage of the Brewster School nearby, because every year the strong, healthy Brewster football team comes down and helps them unload the trucks. something which a lot of us are not able to do. Another activity occasionally is the garden club. This low-budget group takes the advantage of our antique and craft markets to set up a booth and sell plants and flowers that go to the benefit of the town. As you know, they do an excellent job keeping the various parks in the town beautiful. Another side event is the Halloween event. The Halloween event got very, very important in the last couple of years because it provided a safe way for the kids to single file, go in one entrance in the fence, go out the other entrance or exit. We were able to control the crowds. They did not go door to door, potentially spreading COVID. Now, that's been a very popular effort, and the one thing I do have to admit is I cannot control the happy squealing of the children. Nobody can do that. I also mentioned the DAR as a possible effect. We haven't done much with them in the last few years. They have helped us out giving tours occasionally. But in past years, especially in the 1950s, the DAR not only partnered with us on some of these outdoor events, but they also were in charge of giving the tours in the house. So we have a long relationship with the DAR. I'd also like to, Pat, you can give out this number 3 here. Give out the third write-up. That just explains what I've just mentioned. Now, I'd like to clear up something about the 300 feet that may partially ease the complaints of anyone who's against this. There's been some concern that the Wolfeboro Historical Society can claim the right to that, a part of what is now the field between the parking lot and Goodrich Road, because the 300 feet does intrude there. Well, there's a missing link here, and I'll explain it by going backwards. That way it'll keep your attention. In 2009, when the farmers market came to the area known as Clarke Park, we were asked, our president at the time was Jim Rogers, he was asked by the Board of Selectmen to sign a release because the 300 feet is about 80 feet onto the grass, which the farmers market used. Jim Rogers signed a release for that purpose and continued it until replaced by Louise Horskin, who has continued to sign the releases. Well, guess what? That was wrong. I'll explain why in a minute. The second thing that happened was in 1979, there was an agreement made between the town and the Wolfeboro Historical Society. It doesn't affect the events, but it simply detailed who mows the lawns, who paints the fence, who can paint the inside of the Clarke house, and who paints the outside, because we didn't have a written agreement. So it documented what we were doing. That also referred to the 300 feet. That was wrong. Why? In 1949, the town found some money. Clarke Park at the time was not a park, it was a field. It was overgrown, it had decaying apple orchards there, and the town came up with some money to create the town park. That's when it was developed in 1949. In order to do that, because we had a lease that allowed us to go 300 feet from South Main Street, which we never did, a lease modification was signed legitimately by both parties, mutually agreed to, that reduced our footage to 200 feet from South Main Street. This has pretty much been completely forgotten for 70 years. The only person who got it right was Dave Bowers in the history of Wolfeboro. That mentions the lease. But Nobody else knew about it because it was one paragraph in 2,000 pages of the history of Wolfeboro. I do have a copy of that lease here, and I'll take a look and see if I can find it. And that'll conclude my comments for the moment. I have some further comments, but they'll depend on what we have in the way of public opposition. Thank you.
Anybody else want to speak to the issue?
Yes, good evening. Excuse me. I'm Paul Manzioni. I'm an attorney in town. My office is right down on Main Street here. I was asked by John Burton and Robert Tuffer to speak for them this evening. They retained my office with regard to this matter. Initially, what I'd say is really my comments on this are not really to address the nature of the activity that's being sought, or even, for that matter, the kinds of activities that have been going on there. I mean, the Halloween thing, you know, it's once a year. It's not a commerce event. It's not commercial. That's not something that is of concern from a legal perspective. And even to express a personal opinion, either on behalf of Mr. Bird or Mr. Tuffer, about the kinds of activities that have been going on in that spot for all of these years. We just listened to it, and they all sounded wonderful, and they've been going on for many years. It's not a criticism of anything that's been happening there. What brought this all to light, as I'm sure the members of the board all know and appreciate, was the farmers market that was going on there, which was clearly, excuse me, a commercial activity, a sale of goods, which is really contrary to not only the intent of the will, but certainly the provisions of the deed and the restrictive covenants, which I'll get to in 1 second. And there's, you know, support for that opinion, even with town council, which I'll also get to. When you're talking about a section of property that's been set aside and designated for quiet, restful purposes, ornamental purposes, it's to be a park, be singled out athletic activities, probably to illustrate the point, as the gentleman who just spoke, he doesn't know what Mr. Clarke's reasons were for that or what his personality was. But that was one of the things that was specific. But it was very specific also, the use of the park was not a commercial use. It wasn't for commerce. It was a park. It was restful. It was ornamental. Those things have meaning, and they do not mean commerce or commercial activity. But that's what gave rise to the dispute about the farmers market. Now, I appreciate the fact that the lease was brought up, but the use of that property right now, and with regard to the request for these permits, is not governed by the lease. The lease is one instrument. There are other things that determine the use and what the town can allow. And the most important thing is, and maybe all of this was a discussion months ago or last year when this came up, but all of what was said just now really has no bearing on the fact that the town has entered into an agreement. In August, September of 2021, the Board of Selectmen entered into an agreement with both Mr. Burt and Mr. Tuffer, and the town is bound contractually by that agreement. That's what controls this issue of whether permits can issue for what's being requested, a vintage market. The agreement covers the property that the Historical Society is talking about. It's covered in the August-September 2021 agreement. And the town agreed last year that this type of activity would not take place, and the town is bound by that agreement. Unfortunately, all these other activities that were mentioned really have no bearing on the decision to be made this evening, because first and foremost, the town is contractually obligated not to issue these permits. not to allow this. As we look at that agreement, which I understand was emailed to the town, and I think each of you had an opportunity to look at it again. Certainly, I hope it was reviewed and understood at the time that the board bound the town to these provisions. But if you look at the agreement, it references the will, it references the deed, and that's important because that puts this whole thing in context. It's the reason why this agreement was made. It's the reason why the complaints about the farmers market were legitimate. Because both Mr. Burt and Mr. Tuffer not only have this agreement to depend on and to enforce, but they also have the deed and they have the will and they even have the lease to enforce. The lease says there should be no offensive business or such activity on the premises. It references that. So these permits that are being requested would go against not only the will, the deed, and the lease, which says there shall not be any offensive trade or business. So whatever Mr. Clarke was, one of the things that clearly he did not want, and we heard today when he did things, they were charitable or he had dances and he didn't charge money, it's clear that this property was never intended by him, either in the lease, the deed, or the will, to be a place of commerce, to be a place where goods are sold, where people drive up and park and then go purchase and get back in their cars. And a vintage market, by definition, is obviously a commercial activity. How many people will arrive? Where are they going to park? They're going to come and go. That was what gave rise to the issue regarding the farmers market. But it was resolved. The town of Wolfeboro resolved that issue. It didn't go to court. Instead, an agreement was reached between Mr. Burt and Mr. Tuffer and the town. That agreement clearly references the property that involves this request for the permits for the vintage market. This agreement covers that property. It says in Section 1, it's a 2.8-acre public park. It's bordered entirely by South Main Street, Clarke Road, Goodrich Road, and East Clarke Road. It then references the provision in the deed. By the way, the provision in the deed says the granted premises are to be used solely. The word solely, that's the only use. That's what solely means, solely as a public park of ornamental, quiet, and character, and for restful purposes. And then it says, and not to be used for baseball games. That's an addition. That's why the word and is being used, the word solely. So commerce was never a part of what this property was. That's why I think the town settled this issue by entering into an agreement. And the town says in that agreement, there will not be any more farmers markets after 2021. And then the agreement talks about traffic, congestion, noise, light disturbances to neighbors and passerby. If you have a vintage market and you have people coming to purchase and driving up and parking and getting out and then leaving, how many cars, where are they going? Isn't it again a situation where commerce, the sale of goods, is being carried on and there is a potential of serious traffic congestion, noise, and so forth, the very thing that the agreement says that the town has agreed not to have happen any longer. The agreement goes on in section 11. It talks about the prohibition of non-food items. And then when it talks about farmers market, as used herein shall be interpreted liberally to include all similar types of activities, regardless of whether they are advertised or referred to as a farmer's market. And that was in there specifically to prevent any other use of this property by the town or permitted by the town that would involve the sale of goods, commerce. This agreement, the town committed not to allow any further commerce or commercial activity for the sale of goods. Now, in his will, we discussed the major provisions, and it's true, and there's documents that were just submitted that Mr. Clarke suggested that the house be used as a museum. So that's fine. That's not a store. It's not a market. It's a museum. It's not a place where people are coming and going. The area was to be kept as a park or a garden. Now, I'm not the only one who interprets it this way, and we didn't get to the point where a judge in the Superior Court interpreted this, because the town resolved this by entering into an agreement and making a commitment that on this property, this kind of activity will not take place. That's the town's commitment under the agreement. But town council back in 2001, Attorney Puffer, wrote a letter to the town manager and expressed a legal analysis in that letter, which is completely consistent with everything that I'm saying now, and probably formed a basis for why the town saw fit to enter into an agreement that prohibits this kind of activity. After citing case law and talking about how the town should respond to these issues about what kind of use should be permitted, Mr. Puffer also said, this is on December 5th, 2001, quote, "In my opinion, a multi-day craft and antique show would be inconsistent with the designated use as a park or garden." I mean, I think that's pretty straightforward. It's not even rocket science. If you're having something of a commerce activity going on the property, it is inconsistent with the use of the land. The town was bound by those requirements of the deed and of the will, which is why the town, I think correctly, entered into agreement where it said this activity will not occur after 2021. Mr. Puffer went on to explain why it's inconsistent, and he said because, quote, "the proposed use would inevitably interfere with the general public's right to use the property as a park or garden," end quote. It makes sense. When you have commerce there, you are interfering with the public's right to use it in the way that Mr. Clarke intended the land to be used when he donated it in his will and when he granted it in his deed. In 2009, Mr. Puffer had the same conclusions and advised the town. He said in his letter of April 1st, quote, "A craft and antique show is clearly a commercial activity unrelated to the use of the property for a park or garden," end quote. That's the point we're making tonight. The activity that's being requested is inconsistent with the original intention of Mr. Clarke, but most importantly, and what controls, is that it violates the contract. It violates the town's obligations under the agreement that was made in August and September of 2021. You look at that agreement, you construe it in the context. When a court construes the language of an agreement, it does so under the entire circumstances, in the context of what led up to the agreement, including the will, the deed, the lease. All of that will be instructive. But it's clear to me that the language in this agreement says after 2021, the farmer's market or anything like it, whether it's called that or not, cannot take place. And so the only thing I want to say about the request for permits, and by the way, obviously these comments and points that I'm making apply to all of the other items on the agenda for requests for permits. I think this covers each of those requests, is that under the terms of the agreement, the deed, the will, the lease, this is a use, a commercial activity that is not permitted. Regardless of what has happened historically, the agreement now exists, and the town is obligated. to honor the terms and the commitment that the town made through the selectmen and through the board. So we would request, and on behalf of Mr. Burt and Mr. Tuffer, that the request for the permits for the vintage market, something that's obviously commerce, that it be denied because of the agreement and for all the reasons that I've detailed. Thank you.
Anybody have any questions?
Yeah, I have a couple.
Sure.
Have you ever been to the Farm Museum, the Boat Museum, or the Wright Museum in town?
I have.
Do they sell things in their museums?
I couldn't answer that. I'm not.
I'll answer.
I'm not enough
I'll
familiar
answer it
with
for you. Yes.
Yeah.
Yes.
Okay.
Yes is the answer.
No.
Are those considered when they sell a boat to a child in the boat museum? Is that an offensive business or trade?
It wouldn't be offensive. It would only be offensive if it were done in a context of someone who donated the land, said, I only want certain uses to occur on this land. And so the word offensive, something that's offensive to you may not be offensive to me, or vice versa.
So in other words, there isn't a standard definition for offensive that we can agree on.
What happens is that the word offensive is to be interpreted in the context in which it was made. So for example, if Mr. Clarke was the kind of person who did not feel that there should be commerce or the sale of goods for profit or for money or for whatever reason taking place on a piece of property that he designated as a quiet, ornamental, public park or garden, Mr. Clarke may feel that if someone were to go there and attract customers and traffic back and forth and sold goods, that may be offensive.
But Mr. Clarke isn't here, and we really don't know exactly what his intents were because there's conflicting interests based on what has happened, what he willed, what he leased, a lot of other things. So my other question is, if they had their venue inside the buildings, then isn't that a museum activity?
In other words, you're asking if items were being sold inside the building.
Like the Wright Museum, the Farm Museum, the Boat Museum, like the Museum of National History, like the Smithsonian, like every museum in the country, yes.
If the use were ancillary to the museum, in other words, if they took that building and turned it into a store.
Well, no,
so
museums.
You're saying as an ancillary use to a museum, could they sell items regularly? Probably as a museum.
Correct, because museums sell things.
I don't know whether that would violate Mr. Clarke's intent, however. That's a different subject.
Well, his intent was for a museum, and museums sell things in their gift shops and in their buildings.
So
Museum of Science, I can keep going. I have a list of 1,000 museums.
And back in 1915, when he had this intent, then museums must have sold things, because we would have to understand his intent back in 1915.
Aha.
But I don't know the answer to that.
Correct.
Right.
Linda?
No, I'm going to make my statement later.
Okay.
Stuff I'll do later.
I have when you first started, you made some accusations of the things that the society wants to do as being offensive. I don't like the way you presented that.
I don't think I said that.
Well, that's what I heard.
Yeah. Okay. Yeah.
I don't want to get in an argument, I'm just saying.
Right.
The other thing is, these are 4 different applications for 4 different times. Not every week. They're over a period, I believe, of 4 months.
Yep.
1 day, few hours, 5 hours each day. I can't see how that could be offensive. But anyway, I think it's pretty peaceful. It's been done before. You also mentioned something about food, and there is to be no food on that property to be sold or consumed unless somebody brings it with them. So I don't see how this is considered commercial. I'm pretty sure that the society is a nonprofit, as most of these museums and stuff are. So they're not really in it to make money. They're in it to bring people into the community and onto their property that they've leased, and show people what they have, just as part of an additional whatever, for those 4 days. It's actually not even 4 days. Well, it would be probably 2.5 days total, hours. I find that to me is not overbearing. I don't think it's takes away from the peacefulness of that area at all. And that's basically where my notes take me at this point.
Dave, I guess I'm not quite understanding the process here. Usually we have the public hearing, we hear from anybody, close it. I've got things to say, and I'd like to hear from everybody and then make the statement. So are you going to?
Yeah, does anybody else want to speak to this? Go ahead.
Thank you.
I'd like to discuss a few legal points here. One is that a lawyer's opinion is simply a lawyer's opinion. It is not a court ruling. There have been no court rulings on this issue. I will also advise that we do sell items in our museum, indoors and outdoors. They are history related. We sell books on history. And I agree with you, I've never been in a museum, including the Smithsonian, that doesn't have a gift shop anywhere in the world. So that argument really has no basis at all. As far as being offensive, I agree with you, Mr. Senecal. There is nothing offensive in any of the work we do. I'd also like to mention that we're a fairly low-budget operation, but we're not fully town-funded. The town gives us some money, but it covers about 30% of our operating budget for the year. We have to raise the money somewhere. We do that by making people aware of the museum, by getting people into the museum, and we give the public and the businesses in town a benefit when people come there. We also don't charge very much. It's only $4 to get in, and if you're a member, you can get in as many times as you want, and the membership fee starts at $10. It's very low, and you can bring in as many guests as you want with no additional charge during our open season. Now, certainly it's a stretch calling our business a business or offensive. Mr. Puffer's earlier opinion, which I do not have a copy of, and I cannot comment because I don't have the full context of it, but we are certainly not a multi-day circus like the commercial operation that goes down in Brewster Field every year. We're nothing like the hospital fair, which also uses that field and brings in carnival rides. We have never intended to do anything of that, and we agree that that kind of thing would definitely be against all the documents. I also note that the town has a long history of allowing events to go on in town-owned properties, such as, first off, the Clarke Park, but also including Kate Park, Dockside, which is actually closed off to the public. You close the parking places for boat and car shows on a regular basis, and nobody complains about that. But the strongest point I have to make, and I'm glad he referred to the agreement that was made last year, is that agreement is illegal. Because that agreement should never have been signed. First off, it's poorly worded with the words liberal in there, but it's not legal because it has the effect of changing a legal lease between the Wolfeboro Historical Society and the town of Wolfeboro. They are the lessor and the lessee, but for practical purposes, it's easier to understand if I use the words landlord and tenant. General document in every state in the United States is approximately this: a lease cannot be altered except through another written agreement signed by both parties unless the original lease specifically gives a party the power to change something on their own. There is no such clause in the lease between the town and the Wolfeboro Historical Society. This is akin to a landlord renting a house with a provision that says you can have pets. And halfway through, the landlord says, no, you can't have pets. I've just changed the lease. That will not stand up in any court, any civil court in the land. By the same token, there's protection for the landlord, such as you can be evicted if you don't pay the rent. This fundamental basis for landlord-tenant relationships has been around for hundreds of years. The document that was signed, was not even presented to the Wolfeboro Historical Society until we were blindsided by it 2 weeks ago. I don't believe that document will stand up in any court of law.
Is there anybody else who wishes to speak to this? Yes, ma'am.
My name is Kathy Fairman, and I'm a business person here in town and also a member of the Historical Society. My relationship with the Wolfeboro Historical Society and the Clarke House Museums goes back 46 years to 1976, when I collaborated with them and the Wolfeboro Chamber of Commerce on doing a collection of old photographs of Wolfeboro that's we put together as a bicentennial project 46 years ago, which pointed out to me that in 4 years we'll be celebrating the 250th anniversary of our country, but that's another day. That collection of photographs was made possible because of the dedication of the members of the Historical Society. Many of them who were here at that time are no longer with us. But they were preserving them and identifying the people in them and the information. And that has continued today. And I've watched the Historical Society and those museums evolve. And I'm not going to try to even touch the legal questions and all that have been brought up today. That sounds complicated and something that needs more explanation and clarification. But I just like to speak to the importance of that museum and what it's done and how it's grown and how it's evolved in the way museums have changed in the last almost 50 years. Jean has been working on digitizing and has gotten many of these photographs so that they can now be shared and are being used more than they were. So the days of having a museum where it was just there to save and to have it and preserve it has changed. We realize that the point is to get people involved and to bring them into the museums and have that active. The attorney who spoke said that a museum is not a place for people to be coming and going. It should basically sit there. And I don't believe Greenleaf Clarke had that. In fact, having done some research on this very interesting citizen of our community, he gave the building to the town and then got a little upset when they weren't doing something when it was just sitting there and maybe deteriorating. Well, the town has done more. I know there was foundation, there's been preservation work that was done on that building. The Pleasant Valley Schoolhouse has been taken care of. It was brought to that location so that it could be part of that and remembering what having a one-room schoolhouse was like. The Clarke House, built in 1778, is a quintessential representation of what Wolfeboro started like in those very first years, starting in 1759 when the farmers came here and they started. It's a gem. The Clarke House complex is just a little tiny Williamsburg. It's a little tiny Strawberry Bank. It's there as an example for our citizens and those who visit Wolfeboro to see what we were like over 260 years ago now. And in these years, it's evolved. The people who are now involved with them, and as I watch them, and Louise and Jim Rogers before her, and Mark Lush and Jean Dano, they now have people there in costume who are there to take you on a tour and bring you in. They realize that the way to involve people in our history, our young people, our old people, is to have it living history. So the buildings are open, they're being used in activities. We do historical portrayal, historical figures tea. We couldn't do it during COVID, but we're going to bring that back. And citizens get out there and represent people from our community or people from our nation and tell the story. And it's a living way to tell the story. Having a vintage marketplace is wholly appropriate to those goals. So you bring in the things that people might be selling or might have sold. You talk about the quilts, you talk about antiques. Yes, it brings interest, and yes, it might bring some income into the Historical Society as well, which they definitely need in order to continue the programs and the caring. You know, they're all volunteers, they're not getting paid. A little bit for a docent, I understand. But this is, it seems to me that it's wholly appropriate. It isn't anything like the farmer's market, and that I'm not even going to try to say whether the town has the legal right. You've got to sort that out. But I can tell you this, having those vintage markets 4 days out of the entire summer, half a day, so that we can do that and bring that in is the right thing to do. Thank you.
Anybody else? Linda?
Are you closing the public hearing?
I'll close the public hearing.
Okay. The reason
Discussion.
that I decided to do it after the public hearing was closed is I don't see this as an argument. We all have our own opinions and our own point of view. As we look at the documents, I've spent a lot of time looking at the documents, the will, the agreement, and the statement from Mr. Puffer about multi-day craft and antique shows, which we all see up at Brewster Field and know how large they are and why he might have said that. So this is how I have interpreted, and in my opinion, in the Greenleaf Clarke will, it states in the third paragraph, except as hereinafter expressly provides otherwise. And then he talks about the public park of ornamental and quiet character for restful purposes, and not to be used as a baseball games or any athletics. But in paragraph 5, Greenleaf Clarke will, he refers to a section of the property where his homestead is located. A proper use of said front part of house would be a museum of colonial antiquity. In my opinion, it was Greenleaf Clarke who divided the land around his homestead for a museum, which is different than the rest of the land that is gifted. There was no comment about athletic events or restful purposes. In my opinion, in the 2027 town lease of Greenleaf Clarke's homestead area to the Wolfeboro Historical Society for 99 years, was Greenleaf Clarke's wish for his homestead to be used as a museum. And as we've talked about, a museum, there's traffic, there's people coming and going. So I took the will, then I went back to our agreement that we had with John Bird and Bob Tuffer. And it's paragraph 15, which to me really sets the direction of what this agreement was about. This agreement is prepared to avoid litigation of the issue, specifically addressed therein, namely to prohibit the use of Clarke Park as a farmer's market. And that was the market that was going on, and we agreed to remove that market from the property. In no way did either Mr. Tuffer or Mr. Burt bring up what was going on in the Historical Society land, that there was any issue where the trees had been sold, where you'd had vintage market. They knew that, and that was not part of this agreement. Even though they defined the whole piece of land, I think Greenleaf in his will divided it off. And so I'm comfortable with the town not being part of this lease, and it fits with the will.
Okay. The hearing is closed, so Board, what do you want to do with this?
I have one more, question. I'm very concerned now about our agreement that we signed and its legality.
Well, we're not here for that.
I understand, but that does play a part into the whole decision of what we're voting on. Because if we created an illegal agreement, unbeknownst to us and by an error in our attorney, that does change everything, and maybe that agreement should be set aside.
Well, that's not for tonight's discussion, because we have nothing on it. We have no discussion with our attorney. So I'm looking for a motion if somebody wants to make one.
I'll make the motion, the Wolfeboro Board of Selectmen to approve the Wolfeboro Historical Society to host the Vintage Market on July 9th, rain date July 10th, 2022, from 11 a.m. to 4 p.m. at the Clarke Park Museum Complex, permit number 2022-37.
I will second that.
Okay. Motion made and seconded. All those in favor?
Aye.
Thank you. Now, as was mentioned, and I think the attorney for Mr. Tuffer and Mr. Burt, that I'm assuming that what you said earlier, you're not going to just keep recounting it on each one of these? Because I'm going to bring up the next one now. Okay. Okay, you can do that at some point. All right. The Wolfeboro Board of Selectmen consider a temporary event permit for Wolfeboro Historical Society to host a vintage market on September 10th, 2022, rain date September 11th, from 11 a.m. to 4 p.m. at Clarke Museum Complex. Okay, anybody going to speak to that? Anybody from the society or whatever? They're just going to continue? Okay. Anybody want to speak in opposition? Or make a clarification?
Yeah, just a clarification. I think it's important, excuse me, that people understand whether it's Mr. Burt or Mr. Tuffer, or even whether it's, me as their attorney, we're not in any way criticizing all of the good work or anything that goes on with the museum. None of that. That's not the point of any of what I was saying. And the word offensive, when I first read that, I read it from the will. That was a word of Mr. Clarke, that he didn't want any offensive business, and we had a discussion about what that might mean. So I just want to make sure that the board and members of the public are viewing this in the proper light. We're not here to be critical or to put down all of the good things that have happened with the museum or anything else. My point was simply, and I disagree entirely, the agreement may be illegal as to the lease and the lessee and interfering with their rights, but it is not unenforceable, and it is a legal binding contract between the town and Mr. Tuffer and Mr. Burt. You both had lawyers. The agreement was entered into. That was the point that we're making, and that's what we were here to enforce. Thank you.
Anybody else wish to speak to this as part of the hearing? Okay, if not, I'll close the public hearing. Somebody want to make a motion?
The Wolfeboro Board of Selectmen to consider a temporary event permit for Wolfeboro Historical Society to host a vintage market on September 10th, 2022, rain date September 11th, from 11 a.m. to 4 p.m. at the Clarke Museum Complex, permit number 2022-39.
I'll second.
Okay, all those in favor?
Aye.
Thank you. We have one more. The Wolfeboro Board of Selectmen to consider a temporary event permit for Wolfeboro Historical Society to host a vintage market on October 8th, 2022, rain date October 9th, from 11 a.m. to 4 p.m. at the Clarke Museum Complex. That hearing is open. Anybody wish to speak to it? If not, I'll close the public hearing. Board?
I'll make a motion to issue a temporary event permit for the Wolfeboro Historical Society to hold a vintage market on September 10th, 2022, from 10 a.m. to 4 p.m. at the Clarke Museum Complex.
Okay. Any other discussion? All those in favor?
Aye.
Anybody opposed? Thank you.
We skipped
Yeah, number 2.
The which one?
Number
August
2.
13th.
13. Okay. Wolfboro Board of Selectmen to consider a temporary event permit for Wolfboro Historical Society to host a vintage market on September 10th. That must be the one I had before.
Roman numeral 2.
Oh, yes, here it is. Okay, sorry. I did skip over it because I wrote over it. The Wolfboro Board of Selectmen consider a temporary event permit for Wolfboro Historical Society to host a vintage market on August 13th, 2022, rain date August 14th, from 11 a.m. to 4 p.m. at the Clarke Museum Complex. Anybody wish to speak to that? Not, I'll close the hearing. I'll make a motion that the Wolfboro Board of Selectmen to consider temporary event permit, Wolfboro Historical Society to host a vintage market on August 13th, 2022, rain date August 14th, from 11 a.m. to 4 p.m. at Clarke Museum Complex.
Second.
All those in favor?
Aye.
Aye. Thanks, Brad. All right. The next one is Wolfboro Board of Selectmen consider a temporary event permit for the Wolfboro Public Library to host a children's program July 15th, 2022 in Kate Park Community Bandstand.
Good evening. I'm Joyce Davis, Assistant Director at the library, and I'm representing the Wolfboro Public Library. As we have in years past, we are once again, now that we're sort of post-COVID, starting to do more programming, especially children's programming. So as part of our 2022 summer reading adventure, we'd like to hold a children and family concert in the daytime on July 15th. The program would begin at 2 o'clock, and we would just invite families and patrons of the library and the general public to a concert by a one-man performer that plays multiple instruments and has done programming for children for many years. I'd like to hear about just the description of what the musician and performer, who he is and what he does and where he performs. So we are not planning to do anything but have the concert. We will have our own volunteers from the Friends of the Library direct people to Kate Park, probably just stand on the sidewalk. We're not providing any furniture, no food, drink, no obstructions on the sidewalks or the walkways. So we're planning for this to have no or minimal impact on the grounds. I'd be happy to take any questions.
Board, do you have any questions at this point? Thank you, Joyce.
Okay.
Anybody want to speak in favor of this? Anybody want to speak in opposition? Okay, I'll close the public hearing. Thank you.
Thank you.
Somebody want to make a motion? Luke, how about you?
Yeah, I'll move to approve a temporary event permit for the Wolfboro Public Library to host a children's program July 15th, 2022 in Kate Park and the Community Bandstand, permit number 2022-44.
I'll second.
Okay, all those in favor?
Aye.
Anybody opposed? Okay, next, the Wolfboro Board of Selectmen to consider a temporary event permit for the Wolfboro Area Children's Center to host a color run on August 7th, 2022 from 8 a.m. to noon along Bridge Falls Path, Cotton Valley Rail Trail. Anybody here to speak to that?
I'm Sarah Morgan. I'm on the board of directors for the Children's Center, and I'm here to represent them in the fundraising committee. We are looking at doing a fun run on the Bridge Falls Path. It'll be a 5K event, so it'll kind of be one way out, do a little loop, and come back. It's all to benefit the Children's Center, and it'll be, the funds raised will be used for anything needed, be it improvements to the building, fundraising, tuition assistance, kind of the whole gamut, kind of to bridge the gap that we need, so. And I'm here to answer any questions you may have after looking at the permit.
Okay, anybody in the audience that want to speak in favor or against? Close the public hearing, board.
I'll make a motion to issue a temporary event permit for the Wolfeboro Area Children's Center to host a color run on August 7th, 2022 from 8 a.m. to noon along the Bridge Falls Path and the Cotton Valley Rail Trail.
Second.
Okay, any other discussion? All those in favor?
Aye.
Great, thank you very much.
Okay. Oh, I can't believe we're public comment already.
Now we're
Yeah.
after the other one.
All right, we're into public comment, limited to 3 minutes per person, not to exceed 15 minutes. Is there anybody who wishes to speak to us?
Suzanne Ryan, 2 items. One is a question to the town manager. Have you made a new MOU with the Friends of Popwellan?
We are actively working on it.
Great. And do you have an accounting of their funds to date that they've raised?
I do not.
And it will be bonding time pretty soon. I think it comes June, July for the first go-around. My question would be, if they don't have the funds that they have promised, are we going to be including in our bond for the money that they're lacking, or are you just going to keep after them for the balance?
Excellent question.
Okay.
We received approval on the bonds today, which will be coming in front of the board shortly for signature. The bonded amount is as indicated on the warrant article, period. No more for the Popwellan, no less. And it's a matter of staying on top of the group relative to their fundraising efforts and the contribution to the project.
Okay, thank you. And then the second question is relevant to what was happening here earlier in your public hearing regarding the Clarke Museum. Can I get an accounting of what it costs the town for this litigation that these 2 gentlemen brought against the town?
If you put that into me in a
The
writing,
legal fees that the town has paid?
if you put a request into me in writing, I will vet it and get it to you.
Thank you.
Thank you. Anybody else? Okay, the bulk vote is next. We have a few things, weekly manifests. We have property tax credit and exemptions. We have intents to cut wood and timber. And we have yield tax levy on that timber, property tax refund or abatements, and a raffle permit. Anybody have any questions?
I have a comment, and it isn't on here, under B, property tax credit and exemption. V, Harvey Brook Road, that is a denial. And also 39 Winnipesaukee Drive, the elderly exemption is a denial, but the veterans credit is okay. Can we see if we can get that on? I meant to call on it, and I just forgot.
All right, somebody want to make a motion with those amendments?
So moved.
Okay, all those in favor of A through F with the amendments that Linda mentioned? Aye. Okay, appointments. We have a Deputy Emergency Management Director, Paul Whalen. Tom, is this your time? I know Paul's here.
Thank you. As you may recall, a month ago, the board was kind enough to create the additional Deputy Emergency Management Director position. The reason being, as we discussed in large part to be able to fill that position with a quote-unquote civilian who's not one of our first responders, who can oversee emergency operations in the event that the majority of fire and police personnel and so forth are tied up at whatever the incident may be. Shortly thereafter, for lack of a better term, we did a little headhunting, and Paul's name and history kind of stood out, and he was quite interested, and I guess I'd ask him if that's all right with the board to come up, and I don't know, he needs to introduce himself because he's on the CIP committee, but I believe you have a copy of his resume and so forth, and you can see his background for yourself. We would ask you tonight to consider formally nominating him for that position.
Paul, you want to say anything to us? I think most of us know who you are, but...
Well, good evening.
Good.
Since I did I wasn't quite sure what to expect. I did write a few things, so what the heck, I'll jump in. So I'm honored and excited to be considered as a Deputy Emergency Management Director for the town of Wolfeboro. Most of you know me, or all, from the town committees on which I've served as the Emergency Preparedness Director with Carroll County Public Health, and simply for being a resident of the town. I have extensive experience in the fire service and in emergency management. I'm skilled at communicating effectively with people across various platforms, before, during, and after emergencies. I'm comfortable working with community leaders, emergency response agencies, government, media, and the public. And I believe in the value of public education before a disaster. The Emergency Operations Center is sometimes misunderstood and confused with the Incident Command Post. The EOC is a centralized location of emergency response and recovery support operations during incidents, while the tactical on-scene operations are conducted from the Incident Command Post, which is typically located much nearer the incident. The EOC supports and helps coordinate the Incident Command operations and any other adjutant incident operations. The EOC opens during a large-scale emergency and allows the Incident Command to focus exclusively on emergency operations. To name only a few of the functions, the EOC helps obtain additional resources, aids in controlling spontaneous volunteers, helps with opening shelters, monitors donations, provides public information, and keeps accurate records of the incident. The local EOC will maintain communications with the state EOC during an incident. We are here tonight because Chief Zotti and others had the foresight to ask that a citizen be appointed as a deputy EMD. Most, if not all, emergency service leaders will likely be at the Incident Command Post, including Chief Zotti, our EMD, and Deputy Chief Nichols, our deputy EMD. And they are very likely will be able to ineffectively open the local EOC. So I look forward to working with Chief Zotti, Deputy Chief Nichols, as well as Town Manager Pinto, the Board of Selectmen, and other town officials. Thank you.
Okay. Do we need to
Yeah, if you could make a motion to appoint.
Motion to approve.
Paul.
Move to appoint Paul Whalen as Deputy Emergency Management Director for the town of Wolfeboro.
All right, all those in favor? Aye. Anybody opposed? Thanks, Paul. Okay, new business. Special exemption to permit issuance of building permits.
You have a document in front of you with a memo from Tavis relative to a building permit. Tavis is here to speak on its behalf, and any questions you may have, he should be able to address. Tavis, would you give a little bit of background as to where we're at, and then
I can give a little bit of background.
that would be great. Thank you.
Zoning regulation, section 175, 55.1, it was adopted by the town to allow development of properties that do not have direct road frontage but have a deeded right-of-way to access them. The process currently requires a special exception to the Zoning Board of Adjustment. In that are conditions I called out in the memo, 175, 55.1, C6 and 7. They require that the applicant endorse both an acknowledgement regarding issuance of a building permit on a private way and acknowledgement regarding ineligibility for subdivision approval. Those are two forms that after great length I have been unable to find in this building in any computer or any other form. So I created the form myself. I created one form. It's largely based on the Class 6 waiver form that you are all accustomed to. But the one form is now entitled the acknowledgement regarding issuance of a building permit on a private way and ineligibility for subdivision approval. This was reviewed by town council and approved as submitted to them. That's what you have a blank draft in front of you of. And I'm simply looking, I have a memo to that effect and a suggested motion at the bottom, looking for a motion to authorize the town manager to sign said Town of Wolfeboro acknowledgement regarding issuance of a building permit on a private way and ineligibility for subdivision approval, pending ZBA action to approve a special exception pursuant to section 175-55.1.
I have one question here. How come we aren't asking this to be recorded in the Registry of Deeds? So if somebody else buys the property, they will know that there's no ability to subdivide?
Well, the regulation goes on to say it needs to be recorded, which is why it needs. So we're recording it so the applicant knows it's recorded on the property. It would also carry with the property. I will mention that council did have a concern over the phrase ineligibility for subdivision approval.
Okay.
I think the nuance there is if the property remains a rear lot without road frontage served only by a private way, it cannot be subdivided. That doesn't mean that somebody can never subdivide. It just means they would have to create road frontage in order to subdivide. Does that make sense?
Well, if they're landlocked, they're not going to be able to do that. If they don't have, unless they buy another parcel of land, they're not all of a sudden going to get road frontage.
Correct.
So you're keeping ineligible in here even though council doesn't like it?
I believe the direct quote was, I'm not sure that's enforceable, but it's what the regulations say right now. So I'm asking for approval of this until the regulations can be reworked if necessary and readopted so that it can be a bit tidier. So we will do the recording of this? The applicant has, in these instances, the applicant pays all fees. So I didn't ask who paid the fee. I asked who is going to. You're the town's going to. So it will be your department planning will get this signed by the town manager, and it's your department to get it recorded. Thank you. And the streamlined process, the notice of decision is signed and received by my department, as would this form, and all of that gets recorded simultaneously. Okay, thank you.
Brad?
Tavis, does this new document address at all the issue of the maintenance of the private road, and that the town's not going to do any maintenance? The town doesn't have any requirement to respond?
It says that, yes. It does not address maintenance of the roadway.
Okay. I noticed the one that in the back-hand side did talk about that they were going to be doing the maintenance of the road, and I didn't see that in the new blank document. That's
because I noticed that we're missing page 2. I've got 1 and 3.
okay. Yeah. Yep.
So I had to go to that other page.
That's why I missed it. Okay.
I did the same thing at home. I couldn't figure out, in the copying, they didn't give us page 2 of the blank.
Okay.
So that's why we were,
Yeah. That's where.
Gotcha.
yeah.
So, no, it does speak to, by reason of the issuance of said building permit, the town neither assumes responsibility for maintenance, including snow plowing, nor liability for any damages resulting from the use or inability to use said right-of-way, nor hereby the agreement of the landowner disclaims any such responsibility and liability. Landowner will be responsible for maintaining their access to said real property and does hereby forever release and discharge the town for any loss or damage including without limitation and incurred through the town's failure to provide municipal service such as police, fire, and ambulance, or the landowner's inability to otherwise obtain these services due to the condition of the private way or otherwise, or the use of said portions by landowner and those claiming by, through, or under him. So it's that paragraph is directly from the Class 6. It basically says you're on your own, but yes, you can have a building permit.
Yep.
That's part of this too, then I'm good with it, so.
Yeah, that's right. I did that at home, thinking.
Any other questions for
They
Tavis?
would still receive 911, correct?
Yeah.
Yeah, they will still receive a 911 address.
But the road has to be passable and capable for trucks to get down.
Correct.
Yep. Okay, would somebody like to make a motion? Or I can. Move to authorize the town manager to sign the Wolfeboro acknowledgement regarding issuance of a building permit on a private way or for a subdivision approved following ZBA action to approve a special exception pursuant to section 175-55-1.
Second.
Okay, all those in favor?
Aye.
Thank you.
Thank you.
Thanks, Tavis.
Okay, next is the Wolfeboro Jet Ski License Agreement Renewal for 2022. Somebody here for that?
We do.
Guys,
Hey.
Good.
Kyle Druin, founder of Wolfeboro Jet Ski Rentals. We always have a good relationship with you guys, I think. We'd like to continue that this year and hopefully the following ones as well.
Anybody have any questions for Kyle?
I have a comment. This is something we started, I think when your brother was starting, or was it you?
It was me.
It was you. They were
I
young
was
kids.
16, yeah.
And they went down there, check-in every year, and it's a real success story, and I'm
Yeah.
really pleased that it has worked out so well for you.
Yes, thank you guys. It was all to you. So appreciate it.
Did you start another division in Florida? Is that what I heard?
Yes. Yep. We've got 3 locations in Florida now.
Good for you.
Good, yep.
Thank you.
Okay, somebody like to make a motion?
Yeah, I will make a motion to renew the jet ski license agreement for 2022.
Second.
Okay, all those in favor? Aye. Thank you.
Thank you, guys.
Okay. Next is the Abenaki Capital Reserve expenditure for a Gator.
You have in your packet a memo from Christine Collins from Parks and Recreation requesting to be able to purchase a replacement ATV Gator. She did have on her schedule last year to replace an ATV, which did not happen, but she's coming forward this year asking for a slightly different vehicle. It's much more expensive, but it meets the needs of the department significantly better than what they currently have. Christine?
Thank you. He is correct. I did have it on for 2021. We did actually, I went back in my records and we had a replacement for 2017, but we were able to still utilize the machine, so we kept going with it. We had it serviced. Ben looked at it and he said at this point, no more fixes can be done to it, so we need to look for other options. I had a discussion with my maintenance crew and come to find out the machine we're using is more of a recreational vehicle and not really good for what we're using it for. It was working, but it would be better to have a vehicle that's more equipped to handle the kind of things we're using it for. So that's why I put a proposal together and we're coming to you today.
Yeah, it sounded to me like reading through that it was being used in ways it may not was
Yes.
designed for.
Correct, and I was unaware of that, but I just heard about it, so we are trying to correct that. That is
Okay, good.
And just so you're aware, with this year's appropriation going into that account, there'll be approximately $147,000 in that account.
Good. Any questions of Christine?
Are we going to repurpose the old one, or is it being traded in, or?
So right now, it's not really. It's still usable. So I talked to the town garage, and they said we can still use it, but if it breaks again, it's decommissioned. We won't be using it for that purpose, but we can utilize it right now.
Okay.
If we need to, once it does die, we could see if there's anything on it we could utilize for any of other equipment or something as a backup, but it's not worth any money to sell it.
Just for the public who hears that we have $147,000 in it, the capital reserve account in 2023, we're going to try to replace the groomer, and I think we'll take care of most of that capital reserve fund at that time. So
yes,
that's what we're saving for.
Yeah. So that's another thing where we've made some fixes to the groomer, so it is sustainable right now. So we're hoping, to keep growing that pot until we actually have to go out and get it. But we are always on the lookout for bigger ski hills, trying to replace so we can update.
Any other questions about the Gator? Seems like we're in pretty good shape financially on that.
Yeah, I think we can do that.
So somebody want to make a motion?
Move to authorize an expenditure not to exceed, am I using this amount right here? $36,672.08 from the Abenaki Capital Reserve Fund to purchase a John Deere Gator.
Second.
All those in favor?
Aye.
Thank you. Okay, next we have building maintenance capital reserve expenditure for Fosfield.
So Christine had put together for me a quote for the Fosfield Pavilion. The building is really starting to show some wear and tear on the paint. It's really starting to peel off in some spots. She secured a quote to have the entire facility repainted for $6,000. We'd like for you to be able to consider this so that we can get that done prior to summer. We did check with the contractor, and with the location of the temporary office trailer going in, they will be able to paint around that. So there's no issue relative to that. Again, $6,000 for your consideration for painting that. Current balance when we put the appropriation into that account is going to be over $142,000.
Motion to authorize the expenditure not to exceed $6,000 from building maintenance capital reserve funds to paint the Fosfield Pavilion.
Second.
Okay, all those in favor?
Aye.
Okay, next is the approval, building maintenance capital reserve, Abenaki Lodge, Parks and Rec.
So this is an interesting one. One of the things that we've identified with the dismantling of the Abenaki Ski Lodge is the electrical being supplied to Parks and Recreation is basically a bunch of spaghetti. It all goes into the arena and then is distributed to the lodge, to the maintenance building, to the ski hill, and other assets. And there's some things there that we're not sure where they go. This would take care of reconfiguring it so that there would be a direct shot with an individual meter located at the lodge with an independent shutoff associated with it. And similarly to the maintenance shed, while we have an independent shutoff over there, independent meter, it still runs into the lodge or into the arena rather, and then out. So we are going to be taking care of that. That total project to be able to take care of those is about $26,000. So we're asking for $26,388 to be able to have each of those facilities have their own dedicated electrical service so that if for some reason the ice arena is down we can still operate the other facilities. Right now, if the ice arena went down, you couldn't do it, and we can't. We have no power to those facilities right now.
I think this is a very good idea to finally get that spaghetti taken care of.
Yeah, that's just primary wiring, right?
I believe it's the primary wiring. I believe it's also the installation of a disconnect on the lodge, because there simply isn't one there. So
Same with the shop?
So the shop does have an independent shutoff.
Disconnect.
But this will give the lodge one as well, and as well run one for the base of the hill.
All right, I'll make a motion to authorize an expenditure, the amount of $26,388 in the Building Maintenance Capital Reserve Fund for updated electrical infrastructure at the Abenaki Lodge and Parks and Maintenance Building.
Second.
All those in favor?
Aye.
Thank you.
Okay. Next, we have review of site visit, Abenaki bike trails.
So Linda, myself, and Brian had a nice walk through the woods last Friday. It was quite interesting. There's a lot of work that has occurred out there. Mr. Ford was with us. I did reach out to Fire Rescue and ask them to just provide me some feedback whether or not they're equipped to be able to handle any incidents which may occur out there. They've provided me a document that states that yes, they're pretty well equipped to be able to do that. However, future growth, if it were to occur out there, they would like to keep the door open to potential assets in the future. It was a good conversation with the group. I think we've got a long ways to go before we finalize this. One of the items that Mr. Ford had spoke about, when you look at the 7 spray lines that are out there in the spray fields, he believes that some of the erosion that's occurring on the climb trail, which is just to the left-hand side of the Twister Trail, he believes that if we shut down line 7, that won't pose a problem in the future. There would have to be some correction taken on the climb trail when it gets up near that line, but Mr. Ford believes we could disconnect line 7. He's going to put those numbers together and get back to us. And then there was also an area that there is some concern relative to some environmental problems, the slope that goes into some wetlands areas that need some corrective measures. It was a rather interesting walk. I think Brian and Linda probably should speak more to where we're at.
Well, I can kind of give you some of my ideas. I saw the bank needs to be stabilized and there was some erosion. But I also noticed that there had been individuals riding on the trails, even though they were closed and were not finished. The group did talk about how close the climb trail came to the spray fields, but then there was discussion maybe it could go over the ski area. But I found it very interesting that we have the climb line trail and the flow trail. They're not finished. There still needs to be some more work, and it was hard to tell exactly where they were going to go. They were flagging in the woods, and was that going to be the trail or not be the trail? Yesterday, Brian and I walked Fernal Station, and to get an idea of the difference, those trails were single-track trails. The ones up on Abenaki were double-track. They wandered through the woods. The trails had areas where there were jumps and curves and obstacles, but you always had the ability to go around them. The Fernal Station trails could be used by walkers, novice bikers, pleasure bikers, or mountain bikers. The Conservation Commission used construction contracts to define where, how, insurance, and costs for those trails to be built. I believe that the Conservation Commission process was well done, and in my opinion, I believe it is the correct way to develop the Moore Trail. I think it gives us a good model. And I want to thank Brian for the many articles he sent to the board on mountain bike trails and the problems associated with these trails. After seeing people had ridden on the trails when they were closed, they were great articles, and I think they were sent to everybody. They talked about how much mountain bikes had grown, and so these trails have been built sometime with permission with the landowners, but sometimes without the permission. So it seems to be what has happened. And it says there are problems with rogue builders who built bike trails without permission all over the country. And that's what we experienced in Wolfeboro. So we're no different. So looking at that, on the affluent spray land, a number of hand-built bike trails started being built in 2019 without the town's knowledge. And it was not until late fall 2021 when the Board of Selectmen was informed that it had discovered the mountain bike trails were being built by machines on the Abenaki land in the spray field without our approval. There was a lot of finger-pointing as to which town official, if any, had given permission. In September 2021, the town planner brought to the planning board the town of Wolfeboro, New Hampshire Master Trail Plan. The planning board took no action on this master plan. Not until late October or early November 2021 was the Board of Selectmen provided a copy of the town of Wolfeboro, New Hampshire Master Trail. After learning of the trail building, the Board of Selectmen voted to stop all building on bike trails on town property and to form an ad hoc committee to bring recommendations back to this board. As I've been thinking about it and reading the articles and walking on the different trails, I think the board has kind of three options. One, dismantle the trail built on Abenaki and the spray fields without the board approval. Develop a pilot program using the fall 2021 trails on Abenaki recreational land in the spray field by entering into a construction contract agreement with Wolfeboro Single Track to finish building the climb, line trail, and the flow trail. Also enter into a license agreement with the Wolfeboro Single Track to manage and maintain the trail. After the agreements are drafted and have been approved, after they've been drafted and can be provided to the public, hold a public hearing to receive public input. After the public hearing, the board will need to decide whether they want to sign the agreements or not as a pilot program. Or we can enter into agreement with Wolfeboro Single Track to build and manage the trails throughout the Abenaki recreational land and the spray fields. So I think we're kind of at a point where we kind of need to go decide what kind of direction we want to go in.
Brian?
What's left to say, Linda? You stole all my thunder.
I set you up here for your articles, didn't I?
I can't believe that you don't have something to say.
She talks twice as much as I do. So Jim, I have to apologize to Jim for sending him 500 articles, starting last night, all night long, and this morning. It did. It opened my eyes to see that there's this illegal, they call it illegal, trail building happens throughout the entire country. It happens on airport land. It happens on public land. It happens in private land. A lot of it goes under the radar like, how come there are no maps to these trails? How come you have to ask a local, where are these trails? How come they're not, there's no signage? Because a lot of times the trails want to be hush-hush. And that's kind of what happened here. We really didn't know anything about it. If you go to downtown and you talk to 50 people or 100 people like I've done and said, what do you think about the new bike trails on Abenaki? And they're like, what trails? They don't know. They haven't heard about it. When you tell them, the trails are going to cost $256,000 in donated money. Who's donating that money? What? There's going to be potentially repair costs and maintenance over the, really, who's going to pay for that? So there's a lot of questions. I believe a public forum, if we had one, would be biased. It would all be people who wanted trails that would show up because the general public doesn't know that trails even exist. I think that personally, I think that we should have this go to a vote of the citizens of town the next election. I think that they have a right to know that we are going to take on another Libby Museum, another big asset that is going to end up being managed potentially by the select people 50 years from now, 30 years from now, when the Single Track Alliance no longer exists and we have a lot of trails that we either have to shut down or maintain. Another thing that I found in the articles was environmental damage. Some people say that bikers cause environmental damage. They don't. Biking, hiking, trail running, all is pretty much about the same. Where the environmental damage happens is in the construction of the trails. And it's universally understood that the construction of trails, especially with heavy equipment through the woods, creates damage. The trails that we went and looked at Fernald had two different types of trails. There was small, and let's call them horse paths, through the woods that were made that we saw a wonderful gentleman riding on that said, I prefer these trails. These trails are very nice. They're very natural. He goes, I go along at my 5, 10 miles an hour, 3 miles an hour, and I enjoy them. He goes, the trails on the other side, I don't go on. He said, there's too many obstacles. They're too fast, too many technical things. And by the way, when you walk and look at them, there is piles and piles of debris and rocks and leftovers from when they built the trails. They could very easily have spent extra time, extra money, extra effort, and cleaned it up and made it look more like when they started. That would make it, I think, a lot nicer for a lot of people. That being said, the Fernald trails are a trail that anybody can use. Even, like Linda said, the side that has the jumps and the whoop-de-doos and everything, almost every single place there's a way that you can circumvent it. Now, talking about the bridges to nowhere and some of the other things that are out there, it's a real stretch if you say there's footings when there's just a pile of rocks on one end. And then again, generally when I walk through the woods, I don't see trestle bridges and 200-foot-long wooden walkways. They don't naturally occur. Granted, if you want to get from A to B, sometimes you have to cross waterways. But shouldn't we at least check the environmental damage to it? Maybe talk to DES? Maybe find out if there's a better way to go around or through or over instead of just bulldozing through? I mean, just some thoughts.
Okay. Is there anything else that we need to do tonight on this?
Maybe a couple points. I mean, I didn't go on the walk with you guys there, but just from some of my experience of building some of the cross-country ski trails and stuff, to the point where you guys talked about over at the Fernald trails over there, with debris still sitting on the side, stuff like that. It's very easy, while you're out there building those, to spend that little bit of extra time to bury the rocks, clean up, get your slopes on there so that when you come back to get it all grassed in and stuff, it's a nice looking path out through there. It doesn't take that much more time to do that. I mean, I did that for years on the cross-country trails and stuff to make them look good and stuff so that people would
yeah, there's a safety issue too, Brad. If somebody falls cross-country skiing or biking and they fall into a pile of rocks on the side, it's a lot worse than falling into a pile of leaves.
And then the other point I wanted to make, you talked about 3 choices there, Linda, and I'm kind of thinking, as you're talking about those, if we did enter into an agreement, I know this is just still in a very developmental stage right now with Wolfeboro single track, and they agree to maintain stuff like that. We'll say in 10, 15, 20 years, whatever, Wolfeboro single track goes away. Now, the town of Wolfeboro is left with a series of trails on our town property. The private property doesn't. We don't have anything to say on that anyway. Yep. Would there be, for conversation purposes, would it be worth requiring some type of a bond from them so that if something like that did happen, there would be money to either maintain or to dismantle the trails so that they couldn't be used anymore? I'm just think of other ideas to kind of protect the town a little bit here.
Kind of where we need to go back.
I think, I know that the Pathways of Wolfeboro Committee, what they disbanded, gave the single track $40,000. And they built, that was their endowment. And they just did a little trail in Abenaki. It was to help out in Sewer Woods. So I don't think we can do an endowment, but we could maybe do some kind of a revolving account, which they needed to put X amount of money in a year. And I know Brian is very much for that. So that is one of the ways that we could deal with that. The reason I talked about a pilot, because I'm not still sure what the impact, if somebody would ride on muddy trails that was incomplete, we'll keep them off just making their own trails through the spray fields and stuff like that. So that was why I kind of thought if we wanted to go forward, it would be a way not to get too caught up, and also see if they could follow the construction contract, because the Conservation Commission defined where it was going to go, what the materials were, what the base was. I mean, it really defined everything and where it was going to go. Because one of the things I noticed, there are flags over there, and they said, oh, well, those blue flags, maybe it's there, but maybe it'll go over here. So it really hasn't finished to be developed, and I think if we decide, and we don't have to decide to do that, that we need to be very specific on where it's going to go and what's going to take place. So
one of the items that was in that master plan was actually the process of decommissioning trails, and basically how to properly block the trail off for access, and then basically let Mother Nature take her course. That is part of that master plan that was developed, and it is laid out.
In one of the articles I sent you, Jim, there was a I can't remember which town in the country it was. They actually cut down trees, dropped them over trails, put boulders in the way. Oh, this was one at the airport. They did everything they could do, and all the trail builders did was come in and build a new trail around and a new trail around, and they just kept on going and going, and it got very contentious on how much was going on. I'd also like to see the Single Track Alliance, which I see primarily as middle-aged and older gentlemen, and I would like to see them recruit younger riders by giving programs to children, teach them the safe ways. If 6-year-olds are going to be flying down the float trail, I want them to have instruction by people that do this every day so that they're safe and they know what's happening. I helped run a road racing team for my son when he was 10 years old, and we rode in groups all the time, and we instructed the children on how to ride in single file, how to correctly pass, all the rules of the road so that they could be safe. And I think that with the amount of injuries you see in mountain biking, some kids are going to go out and they're going to just get it. Other kids are going to go out trying to keep up with their friends. They're going to get hurt. So it would be nice if there were some educational programs for the kids.
One of the things that I would also state relative to those arguments or those emails that you had sent out this morning, one of those I'm very familiar with, and interestingly enough, the property that is being used is actually the property of the Commissioner of Economic Development for the state of New Hampshire. And he is also part of the organization that manages the trail in that community. Yep. Very familiar with that system. And that was one of the systems, if you read through that article, talked about they were built without permission on his land.
Yep.
So.
And I tried to not just put out things that were negative. That wasn't my intention, because a lot of the articles that were sent out, they talked about how there was a middle ground found and how they worked out a solution to it. It was a nice way for us to see we're not in this alone, and there are many, many solutions.
So is there anything the board would like me to do?
well, I think where we're at, Jim, is to go back and maybe meet again with the single track, our ad hoc committee and maybe look at, we've got a lot of meetings coming up. I don't know whether around the 25th of May or whether you want to do it. I'm just looking at Wednesdays. I don't know what people's schedules are like.
I will put a schedule of possible dates together and get it out to the group.
Okay, we'll pick one of those days. We'll call a meeting again and see if we can do some talking with them. But each one of us should kind of think about how we want to go forward with this. Because I think we got to set a direction at some point.
And I do have to say that Linda took it very well when one of the people we were talking to kept calling the easy trails the girlfriend trails.
Yeah.
I was like, are you kidding me?
Yeah, they did.
My wife will wipe me up on the mountain bike trails. I'm strictly on the road. She'll wipe me up all over the place.
All right. We'll continue on. To be continued. Work session request, planning board, reference housing and density.
So I received a correspondence from 2 members of the planning board looking to have a conversation about housing density and CIP process. I'm not sure how you want to handle this. I know Mr. Ford is working on some calculations relative to density. I don't know if you want to meet prior to that to have a brainstorming session with them, or if you want to hold off until such time that Dave has that document complete. Brad, do you have anything else to add to this relative to being a liaison with that group?
Not a lot, other than the fact that, this topic has come up probably 2 or 3 times now since we've been getting some of these projects presented in town here and stuff, that it's something we really need to look at, knowing that we're near, capacity on the septic, on the town sewer system and stuff. I did explain to the board, even last night at the meeting there, that we are waiting on the results of the study for the sewer system, and that's going to be a key piece of information moving forward on before we even start talking about what's available for density and expansion and stuff like that. Another thing that actually came up as part of our discussion last night too was because we had a pretty good discussion. Work session on ADUs, whereas every house lot in the town now by state law is allowed an ADU unit attached, which increases or can increase a bedroom into that formula now. So if you take the houses that are on the municipal sewer system now and add another bedroom onto those, we're going to really understand what the impact of that's going to be on this whole system too. I mean, it could be huge. Numbers probably, you're never going to get 100% of people going to do that, but it needs to be, looked at and thought about anyway. So, my feeling is we really need to have that study results before we can really have a serious discussion about where to go with this. And Jim and I talked about this too and stuff. I think rather than have it as an agenda item, I think we really need to probably sit down with the planning board and as a work session, because it might be an hour and a half discussion, with throwing ideas around and stuff like that, just to get a feel for, what direction we really kind of need to point the town in on this whole thing. So I'll kind of put that out there, see what everybody else thinks.
I'd like to be part of that myself. I have some ideas. I talked to Kathy Barnard the other night about it. And she said, well, she never thought of some of the things I brought up. So.
I'd like to have some information. I would like to have the 2016 master plan survey results, because that gave an attitude. I'd like to know how many vacant lots we have in town right now.
That was one of the things.
Okay.
Build out.
Yeah, I would like to see the zoning map, and they were talking about some changes and what that would do to the different zoning areas that we have right now. I have no idea. I'd kind of like to know, if we increase the density in areas, what Dave Ford felt would be the impact on the roads. And they're talking about doing it all over the whole town. What will be the impact on our fire personnel and on our police? So if we can gather some facts that we kind of know what we're talking about.
Linda, I have that list at home of all the vacant lots in town.
Okay. What's the number?
It's right here on my phone that's out of batteries.
Okay, I'll write it down here. You got it? Okay.
I'll get it to you tomorrow.
Okay. We need some information
Yep.
as we look at this,
So maybe it'd be worth having a discussion with them before all this stuff is available to us, so we can all put all these ideas out and get them on the table. And then we know what facts we need to go hunt for in addition to what we know is coming into us.
I think that's a good idea. That, if I'm correct, the water and sewer is not coming until July. Am I correct?
Yeah, it was my understanding, middle to late summer was my understanding, and, you know, if that's the case, if they want to talk about this stuff in advance of CIP, it's not going to happen because CIP is going to be halfway done by the time, if that report comes in mid-July, we're going to be buttoning up.
You know, and so here we are, we're worried about the development and how dense it is, and yet then we're talking about cutting sections of the spray field off. Somehow it doesn't make sense to me. I'm feeling like I'm being yanked in one direction and another direction. So I think we need to decide what we want to use our affluent capacity for, whether we need those spray fields.
Nothing's been talked about yet either about soil types. You know, there's certain areas in this town that have good soils for drainage and septic systems, and other places that you can't put them. So that all would fall into place with some of this density stuff too.
And I just think of what we have in going down into Winter Harbor in the Cricket Hill Estate area, where we're having issues anyhow because of such impervious surface, and we're trying to work on drainage. That's why I think we want to, I like your thing about the soil, we want to look at what areas make sense to do this.
And there are maps and stuff with all that on it.
I think so,
I have one of those. Okay, other business.
I have one. There was a situation where a lot was being cleared in a neighborhood, and the lot that was being cleared was not a large lot, but it was just a raw land. And this has now happened twice in the location where I live. Both times the lots were cut without either an intent to cut and without building permits in hand. According to RSA 79, I think Section 5, it says that if you're going to convert a lot, you have to have all your building permits in hand. So I want to know how, and I've been told by people that this is something that not only our town, but many towns ignore. And I have a vacant lot at the end of a road by me that was cut 2 years ago because the people came in, clear-cut it without any building permit, found out that they couldn't build their house on it, and it's still sitting there now with all stumps right down to a stream that runs all spring, most of the summer, and starts again in fall. So I'm trying to figure out how this happens. And I do know that I've talked to people who have to monitor the timber taxes, and they say that this is a big pain in the neck, and it has been for years, and it makes their life very difficult. This and other things that can happen.
Okay, anybody else? Committee reports? Brian? Might as well keep going.
So we have the chargers half installed. It was very, very nice that I got information from a citizen in town who said that they already saw 2 cars pull up with people trying to plug into our chargers that aren't operating yet. So we got to get those up and running. We're going to get them going. I'm shooting for a Memorial Day release, but it shows that these are going to be pretty popular if we're already having people at the end of April come through our town. And they were like, they actually told the person, we don't see them on the map yet because we haven't advertised them yet, but we found them and we want to use them. So I thought that was very, very interesting. I've talked to Nancy, and she's healing well. we're working on how we can manage the revenues of the chargers so that we can keep expanding for new chargers going forward. We did hiking and hiking and hiking.
Hiking, yeah.
We hit Sewell Woods too.
That's right, I forgot Sewell.
Yeah,
Yep, we did
and
do
Sewell Woods, we did find that the stone dust trails in Sewell Woods and some of the drainage needs to be brought back to life. It's been 15 years. So how many years since they did that?
Point when you
No, it might only be about 8 years. But we have there are drainage pipes that are just basically set on the ground and other things. But this is not our responsibility. This is Lakes Region Conservation Trust's responsibility. But they have passed the buck over to Single Track Alliance, and they're supposed to be taking care of it. So it's unusual that those stone dust trails are getting a little bit neglected right now. I think they need to step up their game a little bit. Other than that, anything else? No, I think that was it.
Luke?
We did a pretty light schedule. We did a zoning board Monday night, and we had an applicant who brought forth some housing project that's requiring 7 variances, and we got through 2 of those Monday night. So the meeting went till about 9:30. It wasn't that bad. It'll be continued for the following month.
Do you want to tell them whether they gave?
Both variances passed. These were variances pertaining to 2 45-unit multifamily buildings off of that abut filter bed and are off of 109. Both those passed, and what's left to be passed pertain to an adjacent lot that they're proposing manufactured homes on parcels. I believe 90 of them. So it's another density variance. We'll take that up in June.
Are those single wide or double wide? The manufactured homes.
I think I don't know.
Okay, as Brian said, we walked and we walked and we walked. I had a couple meetings with the library trustees. I had a meeting with Wolfeboro Waters, and I had a meeting with, last night, Wolfeboro. We're doing brainstorming now, and then we'll take a break for the summer and then come back in the fall to really get going on it.
Yeah,
That's
I
all.
had no meetings. I was fortunate.
Let's see, last night I had a planning board meetings, pretty much a work session. Some of the things we just talked about here with that. And let's see, Monday night we did have a technical committee there for the Libby Museum, talked about some things there. And I told them that we do have a tentative date set up for the 10th with the Attorney General on the project there. I couldn't talk really much about that because we're not sure what's going to happen there. And also had a community TV meeting last week, last Wednesday. Some things we're at with things going on in the TV station there and stuff, and moving forward with we're trying to move forward with getting some of these outlying towns that are part of the school district that use Spectrum to be able to tie into their system into ours too for the sports and some of the events that happen at the high school level there. So it's still in play. That was it for me.
Jim?
A few items. One, I've been contacted by New Hampshire Electric Co-op regarding they are installing broadband services in a number of communities. I've reached out, had a conversation with Barry regarding the topic, and I'm wondering if there is a Board of Selectmen member that would like to sit down with us when this representative comes forward to have a conversation about this potential. I see Brian raising his hand. Okay. So more to follow on that, and I'll get you the date, Brian. With that said, bunch of meetings are scheduled coming up. Cable Franchise Committee is scheduled to meet May 23rd at 6 p.m. right here in the Great Hall. Public Safety Building Committee is scheduled to meet May 10th, 2 o'clock here in the Great Hall. We received word today that our bonds are approved. So those items will be coming in front of you before I think it's the 22nd for signature. We're going to try to see if we can get them facilitated for the 10th. One of the things that I've been working on quite heavily lately, we've talked about Parks and Rec and being able to get a consultant to come in and take a look at the organization of Parks and Rec. We haven't had any luck at all. So I've actually held 2 meetings to this point with Parks and Rec, and we're working on our own internal organizational assessment of Parks and Recreation. We started out, we held a meeting, we conducted a SWOT analysis of the organization, looked at their strengths, weaknesses, opportunities, and threats. Today we had a follow-up meeting. We looked at that. We had the team look at how they see the organizational chart today of the department, how they see the functional areas of the department today, and looking at those functional areas of the department, what does the ideal organizational chart look like? And it was really pretty interesting what came back. We are scheduled to meet in about 3 weeks again. We're hopeful to be able to put together some sort of an analysis document before we get into budget season. So more to follow on that, but that has been going quite well, well received by the staff, and it's actually been quite informative to me as far as Parks and Rec, their capabilities, limitations, and whatnot. Did the bike trail walk with Linda and Brian and Dave. We beat that up enough. Just would like to thank the board for authorizing the $17,000 out of the Capital Reserve Fund for the dockside paving. That just looks absolutely amazing. If you haven't had a chance to go down there and take a look at that, I'm quite frankly excited to be able to sit down there this summer and have an ice cream because it just looks so nice. And to close up, again, get this plug in, we are looking for recording secretaries for various committees and whatnot. So if there's somebody out there who's interested in potentially taking on some minutes and doing some recording for us, we could certainly use your help. And that's all I've got.
Any questions from the press? Alyssa?
Well, I wanted to add on to what Jim Pinio is saying because I've been following the dock progress, just taking pictures and getting them in the paper. And I've been hearing a lot of compliments about it. And there are also some really good drone shots that I've seen. And I hope the town gets hold of some of those because you could put them on your website. It looks really good. I also wanted to compliment the town, the planning board, for its progress on the 2019 master plan. I sat down with Peter Goodwin and Kathy Barnard, and they checked on the status of various goals. And let's say, I think it's 21% of the 248 recommendations have been addressed already. And then Peter has it addressed into various percentages. And I think that's pretty impressive to develop a plan and then actually follow it. And we see it in our warrant articles and things are getting done. That's very impressive. That's all.
Okay, public input? Anybody here from the public that'd like to speak?
Definitely don't speak.
Okay, seeing none.
I'd like to make a motion to go into non-public session.
Second. All in favor? Aye. We're in non-public.